The Independent News with Giles. We have updated news.
This just sends shockwaves through Washington, and Trump is scared. Polish Prime Minister Donald Tusk just announced something called Investigation Team Number 5, and it's not symbolic, it's a full-scale task force to investigate the Epstein scandal. So while the MAGA-controlled Justice Department refuses to act, Poland just stepped in. Tusk didn't mince words. He said they will not allow cases involving abuse of Polish children by Epstein's network to be treated lightly. Let that sink in. The United States won't investigate. So another country is digging through 3 million pages of documents, photos and videos. But why? Because there may be Polish victims. So Tusk appointed directly to individuals from Krakow who allegedly told Epstein they had women or girls for him. His words, there are more such leads. Investigation Team Number 5 will now examine what they call an organized criminal group of an international nature. Translation, this could be very big. 3 senior prosecutors are leading the probe, meaning this isn't just a political theater, it's a priority level, and that's not all. Poland's Justice Minister Waldemar Żurek is launching a separate task force to review the files and present the Polish aspects of the case to the public. They're even requesting access to classified US materials. Read that again. Another country is asking for America's classified Epstein files because they want answers, while Washington stays silent. No matter where you stand politically, one thing should be clear. Every name should be investigated, every lead should be followed, and if crimes happened anywhere in the world, justice should be served. Now the pressure just went global. Like this video, share it, because the world is watching.
Hello, I am Giles, Independent with the Independent News. How are you two doing tonight? Hey, you got a pretty nice studio there. Let me get to my piece here. As we see, Poland has stepped into the picture with going through 3,000 Epstein files. I kind of doubt that the United States is going to send Poland the Epstein files because it's got Trump and Melania all in them files. Not to mention a lot of billionaires. I don't know what kind of laws that Poland has. Statute of limitations, I don't know if they exist over there. So if girls in Poland were violated by Epstein and Donald Trump and his billionaire friends, I believe it's going to come out. I'll keep up on that because the Epstein files here are getting pretty much noise right now. People are not letting the Epstein files die. They are going to keep pushing and pushing and pushing until they reveal the billionaires, the millionaires, Donald Trump and his henchmen. Not to mention some of the Republican Party that are in the Epstein files. Yeah, we have one in there. I won't mention his name. He says he only went there, took his family there, his little kids there, to have lunch with Epstein, knowing that Epstein was a pedophile. So let's see what happens, and I'll keep you up to date on it.
Shame on the Republican Party for just basically staying silent while such a powerful Republican senator is basically laying in a hospital like a vegetable. But it doesn't surprise me from the establishment because this is what they support. They support people holding on to power until they're practically dead or do die in office. And this is why the state of our country is so pathetic. The Republican Party is all campaigning against communism right now. What about Elaine Chao? Elaine Chao flew to China and met with the vice president just a few days after Mitch McConnell practically died and went to the hospital. So when are we going to call out a possible communist Chinese spy right there?
You're calling his wife a Chinese spy?
Yes, 100%. What woman leaves her husband's side while he is dead or dying in the hospital, flies to China and meets with the vice president? Answer me that.
He's overseeing an investigation that has repeatedly re-traumatized survivors and has sought to bury the case, even as questions remain unanswered about Jeffrey Epstein and Ghislaine Maxwell's vast network of enablers and supporters. Blanche cannot rewrite history or pretend this investigation is over when the evidence shows otherwise. The Senate must not reward this record of failure, deception, and disregard for survivors. We urge the Senate not to confirm him.
Mr. Chairman, Mr. Blanche, you represented the president in at least three criminal cases, the hush money payment case in New York, the January 6th case, and the Mar-a-Lago classified documents case. You said when you appeared last before this committee you would consult with ethics lawyers about that apparent conflict of interest in handling any case involving his personal counsel. Did you consult with Joseph Terrell, a senior ethics lawyer at the department?
I believe I met with Mr. Terrell, yes.
Did Mr. Terrell tell you that ethics laws and policies required that you not be involved in cases involving your prior representation of the president?
Yes.
So in those three matters, the hush money payment case, January 6th case, Mar-a-Lago case, you were to recuse yourself?
I'm recused, correct. Well, by the way, the cases are not ongoing, Senator, but to the extent there's any work around those cases, yes, I'm recused.
So you said to see things that are happening, there was not a single man or woman at the Department of Justice who had anything to do with those prosecutions, meaning the prosecution of the president. So you're saying that it's not a conflict of interest for you to be involved in the firing of prosecutors who prosecuted your client, your former client? There's no conflict there? Is that
no, there is. I wasn't involved.
So
that would be a conflict.
At CPAC, you're taking credit for the firing of these Department of Justice lawyers, but you're not willing to take responsibility before this committee. Is that the case?
No.
Okay.
I'm making, there's a statement I gave at CPAC.
You were bragging about this at CPAC, the firing of these prosecutors, the firing of the FBI agents, the getting rid of everyone who investigated your client. You were proud of that, speaking for the Department of Justice, but you don't think that's a conflict of interest. You moved to vacate, I don't think you're going to deny involvement in this, you moved to vacate the convictions of 12 Proud Boys and Oath Keepers, which erased their convictions, restored their gun rights. These people were convicted in the January 6th investigation, which also involved the president, who you represented. You were involved in dismissing those cases, were you not?
I'm the acting attorney general, so yes, my department moved to dismiss. I was not involved.
So you didn't recuse yourself from that matter? You were willing?
There's no reason to, from the Proud Boys matter?
Yes, it was.
Lawyer, you know the rules. There are rules that say when I have to be recused, and that's not one of them.
And there are rules, and when you're told to recuse yourself from investigations that you handle for the president, you're supposed to recuse yourself.
No, when I represented the president.
You have also said, you've also refused to release Volume 2 of the Special Counsel's report. That was an investigation into the Mar-a-Lago documents case. How is that not an abundant conflict of interest? Refusing to release to the public an investigative report of an investigation into your client.
I am not a judge. A federal judge.
No. The department's position under you, Mr. Blanche, was do not release the report.
So that position...
If you went into court asking them to release it, it would be released by now. So how is that not a patent conflict of interest?
What you're saying happens to not be true. I did not do that. What you're talking about happened before I became the Deputy Attorney General.
So you support the release of Volume 2?
No, I don't, but I'm recused and had nothing to do with that case. Like, you can't accuse me of violating my ethical rules and then lie about what I did.
So you had nothing to do with the decision to prohibit the release of the report? You had nothing to do with the department's position?
I wasn't in court.
No, I'm not asking whether you were in court. I'm asking you whether anyone sought your opinion or used your guidance in refusing to release Volume 2.
When that litigation was ongoing, I was a private citizen, still representing the President of the United States. It was before March. Since March, to the extent there's been anything in front of that judge,
Mr. Blanche,
I haven't been part of it.
I asked you in your last confirmation hearing whether you would release the report? Your answer was no. Your answer was not, I will recuse myself. Your answer was no, I will not release the report. That was your testimony last before this committee. You subsequently were advised by ethics lawyers not to be involved in these matters, but it appears you were involved in these matters. Let me ask you about another matter.
I wasn't involved. You can't say it appears I was involved, but I said I wasn't.
Let me ask you about another one you have your name on.
The truth has to matter at some point.
Yeah, it does matter. We just don't hear much of it from you. But let me ask you about another matter you have your name on. I don't think you can deny responsibility here, and that is the IRS settlement agreement. So you put your name on this. That absolves the president of tax liabilities in the past. The president was convicted in the case you represented him in of falsifying business records in part for tax purposes. Does this settlement not absolve the president of any liability for tax crimes associated with what he's already been convicted of?
That's not what he was convicted of. It not having to do with
tax purposes. I'm happy to read the statement of facts. The participants took steps that mischaracterized for tax purposes the true nature of the payments made in furtherance of the scheme. So you know,
the
Mr.
participant
Blanche,
there was not the president. It was somebody else.
Well, if the president is conspiring with others to falsify business records to help them cheat on taxes, he is also exposed to liability. You know that as well as I do.
He can't be audited for that.
And of course he can be. Of course he can be. And he can be prosecuted for it. But the agreement you signed on behalf of your former client, on behalf of your current client, in a staggering example of self-dealing prohibits that. Let me ask you this. Does this tax agreement, this addendum you signed, also hold him harmless from any audit or tax liability with respect to the billions in crypto money he made in his first year as president?
It's not forward-looking. So to the extent there are taxes filed by the president or his sons or the Trump organization after the date of that agreement, there's no protection.
Well, but before that agreement. So any taxes...
he hasn't filed taxes yet for money he made last year, right? So
yes.
No.
So if he
no protection.
If he filed tax returns this year for money he earned last year, that his sons earned, that his World Liberty Financial, all those people earned and defrauded taxpayers on it, he faces no liability under this agreement you signed.
There's no evidence taxpayers were defrauded, and he is not protected.
There's evidence in this agreement that you've absolved him of any liability over.
No, I just said he's not absolved. So the question
So this agreement doesn't apply to a tax return filed last year or filed this year?
To tax returns filed after the date of the agreement? No,
No, before the agreement. A tax return filed in this calendar year before this agreement.
Before the agreement, it applies, not after.
Okay, so for a tax return filed this year for last year, for the billions he made, there's no tax liability even if he cheats on his taxes or his kids do or his business do. He is absolved of that further potential liability.
No.
Well, it's in the plain language of your agreement. Did you write this language?
You have to use the facts, though, that he hasn't filed taxes yet. So when he files taxes, there's no protection based upon this agreement.
Did you write this language?
Did I type it up myself?
Did you write this language?
No.
Well, you put your name to it.
I did.
So who wrote this?
I don't know the person that actually typed it. I don't know who it is.
Was it one of the president's lawyers, or was it someone from the Justice Department or IRS?
This document would have been somebody within the Department of Justice.
But you have no idea who that is.
I don't know the name of the person that typed it up.
And did you debate with them the statute of limitations, which clearly would preclude the president's claim, this $10 billion lawsuit?
We had extensive discussions internally about the underlying litigation.
And did you reject the statute of limitations defense?
Reject.
But you signed an agreement for the U.S.
There was discussion around
you signed an agreement for the U.S. basically indicating that the Justice Department's position that the statute of limitations applies doesn't matter.
I did. That's not what I said. I didn't say that anywhere.
Who rejected the 25 defenses the IRS had to this sham lawsuit? Who rejected them? Who said that these defenses we're not going to accept, we're just going to go with the president's agreement in the slush fund, this immunity?
There was a lot of discussion internally.
But you made the decision.
What's the decision? What do you mean?
You made the decision to not defend the IRS and the Justice Department. You made the decision instead to sign this slush fund agreement.
We made the decision to settle the case, correct?
Yeah. And in doing that, you basically decided that you were going to be the lawyer for the president and the lawyer for the IRS and the Justice Department. As the court found in this case, there was no adversarial relationship.
Yes,
the court found it was a sham. It was a collusive relationship. And what I don't understand, Todd Blanche, what happened to the Todd Blanche who was a prosecutor in the Southern District of New York? What happened to the prosecutor people had respect for? What happened to the prosecutor who once respected the rule of law? What happened to the prosecutor who said that there wouldn't be a whiff of political partisanship and then prosecutes the president's enemies over Seychelles cases, over making a video stating the plain law and Constitution? What happened to the Todd Blanche of the Southern District of New York that could convert him into you, someone willing to say the president has both the right and the duty to prosecute his political enemies? I cannot imagine the Todd Blanche of the old days would have ever done that. What happened to you, Todd Blanche?
Thank you for having us on this afternoon.
Absolutely. Let me read to our audience some of the key passages, just a couple, just to get the idea of what you, Judge, and your fellow judges were able to accomplish in guiding the court, at least providing her with the law and the facts and the jurisprudence in order for her to render her decision. Here's what she says. This is starting on page 2. Says, after review of the record and the party statements, the court declines to adopt or accept the credulous exercise of divorcing President Trump's current job title from an understanding of what happened here. She then goes over what happened here. She said that perhaps the most startling misstatement advanced by plaintiffs is their characterization of this case as ordinary. The parties here are not private actors to a mine-run dispute, recounting their proficiency in the art of the deal they negotiated. Lead plaintiff and defendants are public servants, the pinnacle of the executive branch, sworn to uphold the law, faithfully perform the duties of their office, protect the interests of the American public. The issue before the court is whether, instead, they ignored ethical norms, court rules, and legal authority to manipulate the judicial process. The issue is whether they did so to gild their efforts to gain unprecedented access to the public fisc with the patina of legitimacy. There is nothing ordinary about this case. It is the very definition of sui generis. Judge, your comments about Judge Williams, is this what you had hoped that she would do in her 56 pages?
Michael, Judge Williams' opinion is a magnificent decision on the rule of law in America. Before I answer that question, though, I want to thank you and Legal AF and Midas Touch for the
Want to start a podcast, but not sure how? Riverside.
The courage to represent the other members of the free press in America, many of whom have refused to carry forward with their responsibilities as a free press in America. Now, the wheels of justice and the wheels of the rule of law always grind slowly, very slowly, but they always grind inexorably to the point of and in the direction of absolute faithfulness to the rule of law. In the past year and a half, since Donald Trump took office again, those wheels of justice, those wheels of the rule of law have been grinding slowly at first, but then gradually faster and faster toward the rule of law in America. And at this point, I'm prepared to say that the rule of law through the federal courts of the United States have rendered their final verdict on Donald Trump and his administration's effort to subvert the rule of law in this country.
Judge, and thank you for your compliment. And of course, Judge Williams complimented your group and the other friends of the court. Here's what she said in her footnote on page 53 of her order. The court acknowledges and thanks court-appointed amici and their firms, that's you, Andre, for their willingness to review the unprecedented jurisdictional questions presented by this case, their thorough and well-reasoned scholarship, and uncompromising commitment to the rule of law, along with those of the organizations and lawyers referenced supra, are hallmark of a vigorous, independent legal profession critical to sustaining a vigorous, independent judiciary.
Michael, those statements by the court are immensely satisfying and gratifying to all of the judges in America, and especially to those judges who filed the amicus brief in this case. But beyond that, I won't have any comment on behalf of this group of judges as to her opinion. But this is what we argued for as a friend of the court. And as you said at the beginning of the hour, all we did was brief the court on the applicable law on facts, and the court rendered its decision based upon our brief and the court's own evaluation of the facts and the law.
Before I turn to you, Andres, let me frame a new issue, because it looks like the Department of Justice, captured by Donald Trump, has ignored about 99.9% of what Judge Williams wrote, and has latched onto and lighted onto one paragraph and one footnote. I'm going to read it to you, and I want to get your impression of this. They're now taking the position. It's almost like the Dumb and Dumber movie. It's like you're saying there's a chance. So the release that Todd Blanche signed the day after he created the weaponization fund through a phony bad faith settlement of a lawsuit that should never have been brought, in which he alone unilaterally granted to the Donald Trump, his family, organizations, and affiliates a super pardon from tax liability and audit exposure and criminal liability. That's not before the judge. That still stands. That we still have that in our back pocket. Here's one section of the 56 pages that there looks like they're relying on. She says that bottom of page 37, in dismissing the non-parties' claims of collusion, plaintiffs reveal the true position of the parties and say the quiet part out loud. Quote, regardless of whether plaintiffs had ever filed this action, the government and plaintiffs still had the power to resolve all disputes between the parties. The power to resolve was never a question before this court. Whether executive branch actors can privately agree to give themselves and their former clients blanket immunities and billions of dollars in tax monies for legally undefined grievances was never an issue advanced in this court. The question is whether the parties could do so by claiming to be adverse and engaging the legitimacy of a court proceeding, and the answer is a resounding no. So they're latching onto that in another footnote. What do you make of that, Andres?
Well, and Michael, there's a lot to talk about what the judge did and what the relief is, but I would be very careful if I were them. I think they're overreading, as you say, one cherry-picked point. They need to look, when they're looking at footnotes, they need to go to footnote 59. By the way, this is a very well-done opinion. I'd recommend it to any of your viewers if they have a chance, at least to look at the facts. But in terms of what this judge said, besides what you just referred to, which is not a positive for the president or the Department of Justice, she says, however, this decision should not be understood as a final determination regarding any fraud perpetrated on the court and does not foreclose the possibility of future relief under Rule 60D3, which is post-judgment relief, that rule. So the judge is saying, do not fool with me. I still have the power to make a finding of fraud in the court, which would carry additional serious consequences.
So she's inviting a 60D3 motion.
If I can just briefly, I wanted to follow up on both your comment to the judge and his response. You stole my thunder because I was going to quote the same language really about the judges. And let me just say the former judges. And Judge Lutich as the leader has been fantastic, but I think it's really important that everybody understand that this group of brave 55 judges have really helped back up the independence of our judiciary and Judge Williams in particular. I mean, Judge Williams is a very strong person. She's appointed for life, but you still get public pressure. You still get these kinds of criticisms from the president and other executives, and it can affect the judge. And I think it is extraordinarily important what your group has done, Judge Lutich. And I'd encourage the other, if I count right, 256, who I think joined one of your bar complaints. So there's a lot of independent former judges out there, and I just want to send that message out. You all are doing important work for the rule of law. Quick shout out, Matt Platkin and his law firm, Norm Eisen and Freedom Defenders, and my young colleague, Daniela Tenito, who've been fantastic in this case. And thank you for mentioning the lawyers. But this is really about the former judges and Judge Lutich and Judge Gertner. And let me just say one more. Judge Williams did not accept other important amicus briefs. And she really relied on this one because the credibility of former judges like Judge Lutich, who was a circuit court judge, an appellate judge in the United States, their credibility is so important. They don't have an axe to grind, and it's really important what this group has done.
Thank you, Andre. So what I would just say to that for your viewers and listeners, Michael, is this. We do know that our colleagues who are active judges on the courts, both federal and state, have been unsupported for the past 2, 5, 6 years, even by the Supreme Court of the United States, and of course, unsupported by the Congress of the United States or the administration or anyone else. We do know that the sitting active judges appreciate our interest in the cases in which we've filed amicus briefs. It's, as I said, it's gratifying, but your listeners and viewers must understand that all we have done as former judges is file a brief which anyone else could file. Now, to the credibility point, Andres, this is the point. No judge, and least of all these judges, would file or submit one single word to a court of the United States that judge or that group of judges was not entirely certain was a statement of law or fact. That's a little bit in the weeds, but it's imperative that your viewers and listeners understand that really simple point, which is when we speak in our briefs, there is not even an argument that a single...
Prove your point, and I've been a proud member of the Southern District of Florida for over 30 years. I know Andres is my contemporary and my peer. I was so proud of what Judge Williams did. She's got the bona fides to write it. She was the federal public defender for 2 different districts before she became a federal judge. But I was so proud of this particular Southern District of Florida, one that Donald Trump often handpicks as his venue of choice for God knows what reason, other than to try to get judges up in the northern part of the district like Judge Cannon. But he keeps filing in Miami, and he gets judges like Judge Giles and Judge Williams and Judge Ungaro and other judges that are applying the facts of the law, and they're writing statements. This will live on, in history, the way that she has written this. To prove Judge Lutich's point, when I'm an advocate in federal court, the only thing that Andres and I have is our reputation that the judges can trust and rely on what we say. They may not rule in our favor, but they know if they ask me a question about a case, a precedent, or a fact in the case or in the record, that when I speak, they can rely on it as an honest officer of the court. And that is done with the Department of Justice. They don't have that presumption of regularity or good faith any longer. Certainly not with Todd Blanche at the helm or Donald Trump at the helm. And I think that's what Judge Lutich is saying. When you guys write your when you write it down, judges can sigh a little relief and say, okay, here's a nonpartisan, independent analysis of the issues. That's why she reached out to her own amici, right? She picked out former Judge Gleason and a former Solicitor General to give her guidance on some jurisdictional issues until the cavalry arrived, right?
So, Michael, let me address that for a moment and give some context, if you will. So, for 150 to 200 years before the federal courts, that I am unaware of a single instance in briefing and especially in oral argument before a court where the litigant has evidenced the contempt, the utter contempt for the court and for the rule of law and for the Constitution of the United States, that this administration, through its attorneys general and its Department of Justice officials, have shown to the federal courts of the United States every single day for the past year and a half. This is not just unprecedented. This is forbidden by the Constitution of the United States, Michael.
Well, maybe it's because people like Todd Blanche have lost their way. Look at this Freudian slip during questioning today by a friendly Senator Kennedy from Louisiana to Todd Blanche, where he's completely lost sight of who he is or what his job is in the Department of Justice. Play the clip.
Are you and President Trump friends?
I'm his lawyer, was his lawyer, and now I'm the Deputy Attorney General. So I met him as his criminal defense attorney. I'm not sure there's very many people who have ever had a criminal defense attorney who calls that person their friend. I now have a...
Well, let me put it this way. Are you enemies?
No, we're not enemies at all. No.
Yeah, he forgot. I'm his lawyer. I am. Could you imagine Merrick Garland or any attorney general in history forgetting who his client was, as in the United States of America and the American people?
No, and it was I saw the Freudian slip where he says, I was. Judge, let's not forget, Judge Williams is also a proud alum of the U.S. Attorney's Office here in the Southern District of Florida, as I am, before she was the public defender. This is an indictment of the conduct of the Department of Justice. It's a thoroughgoing indictment of the conduct of that gentleman who's up for Attorney General and of the United States Department of Justice. And it will stand, Michael. I think this is a moment of shame. As a former prosecutor, very proud of my service. It's a moment of shame for our Department of Justice.
Let me read, before I turn back to the judge, let me read from the order, page 50, 56. You can pick any other page of this and read it aloud. And I think law students and civic-minded people should all do it. We've posted it up on Legal AF Substack. Defendant's conduct is equally untenable. It is telling that the Department of Justice, which is tasked with enforcement of United States law, has remained conspicuously absent and silent when serious questions about this matter have been raised. And when representatives did choose to expound on the department's conduct, they offered misleading explanations of the facts and the law. In abdicating its responsibility to zealously defend the interests of the United States, the government entered into a settlement, in quotes, that deviated from its litigation posture in similar actions, disregarded DOJ policies, and accomplished objectives beyond those authorized, as well as those specifically prohibited by law. Under these circumstances, the court may reasonably infer that the government failed to defend the lawsuit or to respond to the court's jurisdictional inquiry because its position would not withstand judicial scrutiny and because resolution of these threshold issues identified by the court would not have favored the preferred outcome to this case. I mean, Judge, have you ever, you've been a judge. You ever written words like that about the Department of Justice?
No, of course not. But the point is, no judge in American history has ever had the occasion to say anything like that. Judge Williams' opinion, as a consequence, will now be studied and parsed forever throughout the remainder of American history. It is unassailable, but most importantly, it is a statement of the rule of law in America in the context of the President of the United States having attacked and gone to war with that rule of law through his attorneys general, Todd Blanche. I'll go on to say, to the relevant point today, if the Republican Senate confirms Todd Blanche to be the next attorney general, it will represent to America an American.
These respected federal judges that signed onto this this letter are respected judges. And they're giving their opinion. You never hear anything from them unless something this serious comes about the corruption from the Trump regime and Todd Blanche. Blanche should not be confirmed to be the DOJ. He should never be confirmed to be the DOJ. He's as crooked as Donald Trump. He sat up there in his confirmation hearing and he lied his ass off completely. If the Republican Party confirms Blanche to be Attorney General, then everybody that's out there that's voting should step up and get rid of the Republican Party that is in the Senate. Because they don't mean you any good, especially if they make him Attorney General. Do you think they care about you? Do you think they care about what you think? They're afraid of Donald Trump. They're afraid of Donald Trump primarying them in their districts. They don't have to worry about that because their districts are going to get rid of them after the shit that they have pulled and backing Trump and everything that they're doing, where they have less food on the table for their kids because they can't pay their rent, they can't pay their mortgage. They're putting a ton of money in the gas tanks, and then you have these you have these idiots going on TV talking about, oh, it's going to end soon. The war's going to end soon. Biden this and Biden that. Fucking Biden's been out of fucking office for over a year and a half. Everything that's going on is on the Republican Party. It has nothing to do with Biden. Nothing at all. And only idiots with green teeth are going to believe anything that they tell you. Fox News, Newsmax, all of them lying their asses off to keep Donald Trump and the Republican Party in office to destroy this country even more than what they did. And Trump's talking about Iran wants a deal. Iran does not want a fucking deal. Donald Trump violated the agreement with Netanyahu. They both violated the agreement, and this is why Iran called off the deal. Iran would not just call off a deal when they're getting everything that they wanted. The 10-point they got me so pissed off I can't even get it out. But it's fucking ridiculous. And then you have these Republican people on Fox News, on especially on X. X should not even exist anymore. It's nothing but a propaganda bullshit app. They lie so much on there. They get their talking points from Trump, and Trump lies all the time. So everything that comes out of X, everything that comes out of Fox News, everything that comes out of Newsmax, ABC, and now CNN is bullshit. CNN, national news is not even covering half the crap that Donald Trump is doing. They're ignoring it. They're going right by it. And it's think that Donald Trump is going to sit in front of a fucking microphone in a camera and talk about fraud in elections when he is the fucking fraud in the elections. He's the one that's committing fraud in the elections. He's the one that's trying to steal elections. Just like he did before when he created January 6th and had them people go up there, had them idiots, not people, idiots, go up there and violate everybody's rights. And then Trump is going to turn around and give them a fucking pardon. Half of the guys that he gave a pardon were nothing but fucking criminals who ended up back in jail with fucking rape charges and assault charges. The Proud Boys. They're a bunch of proud pussies. That's what they are. They're fucking racist groups. It looks like the KKK has worked their way back into our government like they planned a long time ago. And it's time to get rid of all of them. We are getting sick and tired of these fucking racists. Sick and tired of this shit. Thank you for watching Independent News with Giles. And Giles, you are doing a great job. Talk to you later.